Judiciary Committee will come to order. And our first order of business is, do we have any requests for bill introductions from anyone in the committee meeting room? So, yes, go ahead. Ms. Brown, yes, please come to the podium, introduce yourself, and welcome to committee.
Thank you, Madam Chair and committee members. I am Larry Ann Brown. I'm here today on behalf of the American Property Casualty Insurance Association. I'd like to request introduction of a bill dealing with small amount of settlements for young children, young kids.
Thank you. The bill will be so introduced. And then we have Mr. Greg Smith. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Always a pleasure to be in Judiciary. The Johnson County Sheriff's Office has 5 bills that we'd like to introduce this morning. The first is RS 0788. This is requiring a waiver of extradition on felony charges. It's the same bill that we had in here last year, passed out of here, passed the Senate 40-0, and then didn't get out of the House. We also have RS 0833, which is a cold case homicide victim family rights act. This is modeled after federal law that was passed last year, and we simply want to try to bring that to the state level. RS 0834 is the use of a critical incident response therapy canine in court. This is for witnesses, child witnesses, and witnesses that may have emotional or mental issues in the courtroom. RS 0835 is an amendment to the aggravated endangering a child statute, in this case, particularly relating to having fentanyl around a child. The current statute only refers to methamphetamine. We're running into fentanyl much more than we are methamphetamine. And then the last is RS 0841, which is the criminal use of a weapon relating to possession or using a firearm during the commission of certain drug offenses. And we'd like to request all of those for introduction.
Thank you. The bills will be so introduced.
Thank you.
Thank you. And committee, we're going to turn back to the last presenter of a request for bill introduction who did not provide an RS number. So if you have an RS number, please introduce yourself. And
Larry Ann Brown on behalf of the American Property Casualty Insurance Association. The RS number for the minor settlement bill I just requested introduction of is 0885.
Thank you for clarifying that. Appreciate it. And committee, then we have some bill requests for bill introductions from Senator Corson.
Thank you, Madam Chair. I have 2 bill introductions. One is 23 RS 0890. This is establishing requirements for the involuntary discharge or transfer of a resident in an adult residential care facility and the right to appeal such discharge or transfer and setting out the process for that appeal. And the second one is 23 RS 0917, which requires certain juvenile records and files to be automatically expunged from a person's criminal record. Thank you, Madam Chair.
Thank you. The bills will be so introduced. Are there other requests for bill introductions from the committee? I do have several. The first is 23 RS 0433, the Reduce Armed Violence Act, with increased criminal penalties for certain violations of criminal possession of a weapon by a convicted felon that involve firearms. I believe we heard this bill last session, and we'll be hearing that bill again, or it'll be in committee. And we have 23 RS 0745, protection orders and using electronic tracking devices. It's an anti-stalking measure that will give our law enforcement the opportunity to prosecute those who use private tracking devices, like a tile, and if you drop it in someone's purse or in their vehicle in order to track them, and it would be a violation of a protection order or protection from abuse order. So kind of another tool for law enforcement. Then we have 23 RS 0930, increasing criminal penalties on drug-related crimes when the drug contains fentanyl or when the drug's appearance resembles a piece of candy. This kind of dovetails on Mr. Smith's and our sheriff's bill regarding fentanyl to address increased penalties in crimes involving that drug. We also have then 23 RS 0607, which is an act concerning civil actions and relating to causes of actions and limitations on actions for recovery of damages caused by childhood sexual abuse or childhood gender reassignment services. And we also have 23 RS 0608, which concerns the time for prosecution of certain childhood sex abuse crimes. And those bills will be so introduced. And that is our final call then today for any requests for bill introductions. The committee is not meeting on Friday, and we are on call of the chair for Monday. So if you have any further requests for bill introductions, that needs to be concluded by the time we adjourn our committee today, would be in order to get it in the committee today. So with that, then we will turn our attention to hearing on Senate Bill 74. We do have, I have on my list, I think, 8 conferees. I think 8 conferees who wish to provide. Some have been added last minute, so maybe 7, but in any event, quite a few, and we have an opportunity to get to everyone. I'm going to limit testimony to 3 minutes per conferee and to keep us on track. With that, then, we'll ask for a bill brief from the reviser on Senate Bill 74.
Thank you, Madam Chair. Good morning, committee. Jason Thompson, Reviser Statutes Office. For those watching along, Senate Bill 74, you have the bill brief in front of you. Very shortly says, provides for joint liability for costs and sanctions in third-party funded litigation, deals with some discovery disclosures, and requires payment of certain costs for non-party subpoenas. I'll highlight the 3 sections in the bill for you very quickly. First, there's the new section of law, new section 1, that would go in the Kansas Code of Civil Procedure. It provides that any person other than an attorney who's working on a contingent fee basis who has a right to receive compensation that is contingent on and sourced from proceeds of that civil action will be jointly liable for costs that are assessed and for monetary sanctions imposed on the party with whom they have an agreement. So if you're in one of those agreements and you're not an attorney working on a contingent fee, you're liable for the costs and the sanctions just like the party you're in that agreement with. Section 2 then amends KSA 60-226. That is in the Code of Civil Procedure. It's our discovery statute. There's a new subsection, B3 capital B, relating to discovery of third-party agreements. Essentially, you have to disclose them. That's the peanut of that. Finally, Section 3 amends KSA 60-245. That's also in our Code of Civil Procedure. It's the one about subpoenas. There's a new subsection C4 concerning non-party subpoenas in these third-party funded actions, and just essentially says you have to cover the cost of making someone attend one of these. And then I'll see if you have any questions and get out of the way for the many conferees you have behind me.
Committee questions. Thank you. Committee questions for the reviser. If you could just explain briefly on page 2 of the bill regarding current law and disclosure of insurance agreements. It's section 3A on page 2 of the bill.
Sure. Madam Chair, so this again is part of section 2, KSA 60-226, the discovery rules in the civil procedure. A3A, I think it's A. No, it's B. B3 capital A, they're on page 2, deals with insurance agreements. Essentially, it provides that a party may obtain discovery of the existence of an insurance agreement and the contents of that agreement, but the discovery of those items does not necessarily mean those will be admissible in evidence at trial. There are a number of other rules about the admissibility of that and what it can be used for that is not covered here in the discovery statute or covered by other law. So hopefully that start to answering your question.
One last question. Under current law, no motion has to be made by a party in order to obtain discovery of the insurance agreement, or would a motion be required?
I'm rereading it just to make sure I didn't miss something, but it just says a party may obtain discovery. So to me, that's one that you would request. Contrast that with the new one that we're enacting there in B, that the party shall, without awaiting a discovery request, provide this information about third-party agreements to the other parties. So I could be mistaken about that. There may be some other rule I don't know that requires this to be done, but my reading of them is that this new one is required without a request even. And then the existing ones that just say they may be discovered or you may obtain discovery, those are the ones you're asking for.
That it looks like it's permissible. So, and
right, the may to me implies permissive, not an. And like I said, I'm
allowed.
I'm not out there litigating under the code like some of the folks behind me. So there may be some other rule that says you actually do have to turn these over without being asked, but the statute itself just says you may obtain discovery, which to me is more permissive.
And allowed. Thank you. Then we will start with our first in-person proponent, conferee Eric Stafford, President of Government Affairs from the Kansas Chamber of Commerce. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and committee members. Good morning. My name is Eric Stafford, Vice President of Government Affairs for the Kansas Chamber, here in support of Senate Bill 74 in respect of time and saving as much time as possible for Mr. Behrens, who's here on behalf of the Institute for Legal Reform at our request. I'll just be brief. This is similar to Senate Bill 152 from last year that this committee has heard, so the content is not new. What is new over the last 12 months is that one of the questions last year was that, do we even know that if this is happening in Kansas? And the answer last year was, we don't know because it's not disclosed. And included in the PDF copy of our testimony, or the paper copy of our testimony that you should have, would be an article from TechCrunch about a firm that received $100 million in venture capital to serve as a third-party litigation funder. And that firm has been calling law firms in Kansas that we are aware of. I'm sure that there are others who are calling as well. What is also new is a 60 Minutes piece that aired on December 18th and really just talked about how this industry is new in the United States within the last few years. It's not currently regulated. And one of the key quotes from that piece, I've copied and pasted on the top of page 2 from that 60 Minutes episode, where a University of Iowa law professor is talking about the practice of third-party litigation funders and how they are quietly altering the landscape of the judiciary, which is one of our branches of government, and it's unknown. And it's unknown because it's not regulated and there are no disclosure requirements. And I would think that in the vein of transparency that this legislature operates and talks about so often and loudly, that we would want transparency in our courts, just like we do in the legislature. And that is a key component to the purpose and reasons behind Senate Bill 74 and why we are asking for it. Another new aspect that has arisen, Alan Cobb, our president and CEO, was at a conference last week of National Chamber Executives, and they talked about this issue and putting it on the radar of states. And one of the reasons that it's concerning, another article that should be included in our testimony, is concern that sovereign wealth funds or countries that are not necessarily allies of the United States, Saudi Arabia, Russia, China, could gain access to secret information through the discovery requests as being a third party to these cases that the defense has no knowledge of. And so that is kind of a new aspect that brings concern, and would hope that the committee would view that with a sense of urgency. But ultimately, we are asking for Senate Bill 74 to provide transparency for the defense. And I think some of the issues that will be arising from some of the opponents dealing with small loans, small business loans, small medical loans, it is our intent to not include them. We are perfectly happy to exempt them from this bill. We are happy to work with the opponents of this legislation to come up with language that would satisfy their concerns. So have no problem there. Also have talked to some of the opponents of this bill, the actual hedge funds and their organizations. We're looking to we're happy to take out Section 1. We're happy to work with the opponents to find a solution, but we're being told that disclosure is the problem. And if disclosure is the problem, then transparency is the problem. So happy to answer any questions, and I'll defer the heavy expertise to Mr. Behrens and answer questions at the appropriate time.
Thank you, Mr. Stafford. I think in the trying to preserve as much time as possible, we're going to hold the questions till the end from the committee. Thank you. Next, we will hear from Mr. Mark Behrens with the U.S. Chamber of Commerce. Welcome to committee. Please introduce yourself.
Thank you, Madam Chair. I'm Mark Behrens with the law firm of Shook, Hardy & Bacon, and I'm here today on behalf of the U.S. Chamber of Commerce Institute for Legal Reform. The U.S. Chamber is the world's largest business federation and includes many Kansas businesses. In the interest of time, I'll quickly go through. You have my written testimony to the committee. But today we're talking about something that's a relatively a game-changing, transformational event that's occurring in American litigation. Investors that include hedge funds, pensions, endowments, and as Eric said, sovereign foreign wealth funds that are controlled by foreign governments are literally pouring billions of dollars into litigation to finance litigation in the United States. The U.S. Government Accountability Office put out a report at the end of last year, and GAO found that there was roughly $13 billion under management, assets under management at that time, and another $3 billion that were being deployed in 2021. So this is already a massive and rapidly growing business. And one of the reasons that investors are attracted to this is that they can carefully choose their cases. In 60 Minutes, about a month ago, there was an interview with the CEO for I think was the largest funding company, who said that they win 90% of the time because of the care that they use in picking their cases, and that they essentially double their investment in these cases that they win. So it's very lucrative, and it's not tied to underlying market conditions. So in a time like today, where the stock market has been down considerably in 2 years, the bond market is down considerably, crypto has collapsed, funding lawsuits is big business, and it's a very lucrative way to make huge returns when the rest of the economy is struggling. The U.S. Chamber is concerned with this practice because we believe that it'll create more speculative lawsuits, it will prolong litigation, and it makes settlement more difficult and more expensive, because the settlement negotiation, which is usually two lawyers working on an agreement, suddenly takes on a very different dynamic when there is actually a multi-party group involved in the settlement, not just the two lawyers in the room and their clients, but a hidden party that nobody has been aware of, neither the court nor the parties, because this funding is done without any sort of transparency. And these funding agreements can lead to ethical issues too. As a lawyer, I have a duty to put my client's interest first and to exercise independent judgment to do what is in the client's best interest. And that can be very difficult to do if the funding agreement provides that the funder has any control whatsoever over the nature of the case. And even if the agreement doesn't necessarily say that the funder can call the shots, they clearly have significant influence on the case, because the lawyer knows that if they don't play ball, they may not be getting another installment payment, another loan, either in the case that they have or in the next case they want to bring. And so these raise ethical issues in addition to making settlement more complex. As Eric said, there was a 60-minute piece that ran about 3 weeks ago, and it was a terrific summary there by this professor at Iowa Law School, who's an expert in this topic and doesn't have a dog in the fight. She's not representing funders. She doesn't work with the business community. She just studies this issue and writes about it. And she said that the funding industry is transforming litigation in America, because they are deciding which cases are brought, how long they're pursued, when they settle. And this is all done without any regulation or transparency. And the fix before you, Senate Bill 74, I think is a very modest reform, because it's not banning this practice. It's not limiting how much the funders can return. If they want to charge 100% on return, they can get it under this bill. All we're asking for is transparency with respect to the agreements, Madam Chair.
Appreciate your testimony. Thank you, Mr. Behrens. And if you can stand by for questions at the appropriate time, if the committee has any, that'd be
I'd be happy to.
appreciated.
Thank you.
Thank you. Are there any other proponent in-person conferees? Then we also, committee, have proponent written only testimony submitted by Scott Kibbe, who is Vice President of State Government Relations with the American Property Casualty Insurance Association. We also have proponent testimony from Rochelle Colombo, Executive Director, Kansas Medical Society, as well as from Beth Smaller, General Counsel for the Kansas Association of Insurance Agents. We will now turn to any neutral conferees in the committee room or on WebEx. Seeing none, then we will turn to our opponent in-person conferees and hear from Mr. Mike O'Neill on behalf of the Alliance for Responsible Consumer Legal Funding. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Mike O'Neill, representing the Alliance for Responsible Consumer Legal Lending. Your letterhead on the testimony, they go by ARC, A-R-C. This is an interesting area, and it's not well known to a lot of individuals. And what I'm here to tell you is that there are actually two types of companies. One, which is actually the intended company, type of company for this legislation, and then our types of companies. ARC is a trade association that represents companies that provide financial assistance to individuals that are involved in litigation, but they cannot use any of the proceeds of a loan to actually fund litigation expenses. So imagine an individual injured in a car accident, for example, and they may be out of work and that sort of thing, and they have ongoing household expenses, living expenses. These companies, along with other types of consumer lending, will lend them money so that they can get by while their case is pending. The difference is they are strictly prohibited from using that money for the funding of litigation expenses, and that sets them apart from the other companies. And that's what Eric Stafford with the Chamber was referring to. Is we've had discussions with them that have been ongoing, and we appreciate their willingness to work with us. We are not the intended target of this legislation, and it's a fairly simple fix. We expect that we can bring back a fairly simple balloon amendment that once we all agree on the language. We are not opposed to the transparency part of it. We're a regulated lender, and so we expect there to be regulation. We are regulated in the places that we do business, so that's really not an issue. Section 1 is a problem for us because as written, that would include us, and also the definition of third-party lending agreement would also include us. Again, that is admittedly not the intent, and so in the interest of time, I'll just leave it there and expect that when we revisit this issue, when the committee works it, we'll have a solution for that issue. And I'll stand for questions at the appropriate time. Thank you.
Thank you. Appreciate it. Next, we'll invite John Federico Durst Consulting Group. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. John Federico on behalf of the International Legal Finance Association, the acronym ILFA. I'll take, of the seconds I have, oddly compliment Eric Stafford in the professionalism that he showed with a disagreement of the value of this. I wish all our issues were able to be conducted in such a professional manner. He's not much to look at, but he's a professional. We appreciated the debate and the work by this committee last year on the exact same issue, and we appreciated the fact that it didn't warrant advancing the bill. Our opposition to the bill remains the same. We do not understand what the problem is in Kansas. The fact that these companies exist doesn't necessitate that law be put on the books to fix any particular problem. More so, as this bill is laid out, it is forced disclosure between two contracting parties that serves little purpose other than to advantage one party to a lawsuit to the detriment of the other. This funding mechanism, a critical option in almost all circumstances, should not be penalized because it's new or at times returns a profit. It levels the legal playing field for litigants that often pit small against big. Further, in a free market economy, people should be able to enter into contracts freely with their eyes wide open without requiring that the contract containing the details of their confidential business relationship be turned over to their legal adversary. Lastly, the last point I'll make is that this removes, if this law were to be put on the books, because it's a mandate, it is forced disclosure, whether it's relevant to the case or not, there is currently a process by which, if there is a reason that this information be turned over, they can appeal to the judge, and the judge can see if there's relevance or, in fact, it's a fishing expedition. And they can determine whether this information needed to be turned over. I'll say two last things. Transparency, great. Transparency at what cost? This involves no tax dollars. This is not involving the government. These are two contracting parties to this. And at what cost is, it is, the mere disclosure of it is identifying a part of your legal strategy. It should come as no surprise that oftentimes part of a legal strategy is to see how long they can string this out, how long you can pay for legal representation. Lastly, I will say the 60-minute piece that was referenced, there were a lot of interesting pieces, Madam Chair, and I'll close with this on the spirit of time. They started, first of all, I don't think we should set any policy based on what Leslie Stahl has to say on 60 Minutes, but there were a couple interesting pieces. One, they interviewed a gentleman, to my point of small versus big. She seemed to want to trap this farmer who had been involved in litigation. He's a 30-year farmer, sued, won a $23 million judgment. They appealed. He had no money to continue on with that lawsuit. So to quote him word for word, they stepped in and helped us out when we couldn't have gotten money from anybody else. They basically rescued us. And lastly, it was identified by this law professor that the U.S. Chamber of Commerce, the sector that is most concerned about this type of funding, are big corporations, because now there is money to sue them, and this is the key point, and there is money to persevere and not settle at a discount. And I think that's an important point to make. Madam Chair, I appreciate that. Stand for questions at the appropriate time.
Thank you. Appreciate it. Next, we will hear from Rex Sharp with the Kansas Trial Lawyers Association. Please introduce yourself and welcome to committee.
Chair and committee, I'm Rex Sharp. I'm here on behalf of the KTLA, and I've been a plaintiff's lawyer for a long time in Kansas. This just simply is not a problem in Kansas. It's not something that is used. I've been a plaintiff's lawyer for a long time. I have to fund all of my cases. I don't use a bank. I use my own money. I've used it for a long time, and I continue to do it that way. I'm a trained economist. If there was an advantage to using litigation funding, I'd be all for it. I'd certainly try to use that. But that's not something that's going on for my firm. It's not something that's going on in Kansas. You haven't heard anybody come to this committee and say, this is a problem in Kansas. You haven't even heard anybody come to the committee and say, this is even occurring in Kansas. So here's where we're at. It happens on the East and West Coast. I know that because I do litigate in cases on the East and West Coast. It also happens in federal court. I described some of that in my written remarks. But it doesn't happen in state court in Kansas, which is what this legislation is all about. So do we have any speculative lawsuits as a result of litigation funding in Kansas that we need to worry about and do something with this legislation? No, nobody's even mentioned a single case that would be speculative. In fact, the testimony from the proponents was 90% of the cases involving litigation funding are successful. That doesn't sound like speculative. That sounds like pretty good cases to me. I wish I was in some of them, I guess. It doesn't inhibit settlement. There's no evidence of that it inhibits settlement in any way. If it's going to do anything, it's going to encourage settlement because both sides know that the other side can go the distance. Transparency. This one's one of my favorites. The law as it exists right now, if you have a need and you can show the judge you have a need for this particular third-party funding agreement, you can ask for it in discovery, and the judge will say, okay, show me why you need it. Tell me why you need it. Why is it relevant in this case? If it is, then you can get it. It's just like anything else. Insurance agreement, you can get that. Anything else that you think is relevant to your case, you can get it. Ask for it. If it's objected to, move to compel. The judge makes the decision. So transparency is not a problem. Saudi Arabia litigating in state court in Kansas, I just haven't seen that. I don't think we have to worry too much about that, even if 60 Minutes is concerned about it in other places. This just doesn't happen in Kansas. It's a big case, federal court, east-west coast problem. It's just not something that we have in Kansas. And so I would ask that this committee reject this and move on to something that's more important. Thank you.
Thank you. Next, we will have Gary Barnett, Executive Director and General Counsel of the International Legal Finance Association, who's appearing via WebEx. Please introduce yourself and welcome to committee.
Good morning, Chair Warren and committee members. My name is Gary Barnett, and I'm the Executive Director and General Counsel of the International Legal Finance Association. I would like to thank the members of this committee for allowing me to provide remarks on the bill this morning. ILFA represents the commercial legal finance industry, which we heard earlier is entirely separate and distinct from consumer litigation funding. Commercial legal finance refers to the provision of capital to law firms and businesses, which are represented by sophisticated counsel, typically in the form of multi-million-dollar non-recourse investments. ILFA's members are commercial legal finance providers who provide capital to law firms and businesses of all sizes, helping them mitigate risk and allowing them to maintain necessary capital to invest in their growth. And as was previously indicated, also levels the playing field and allows smaller businesses to have the resources they might need in pending litigation. Overall, legal finance drives economic development and job creation in local communities where it's utilized. Many of the concerns we have heard from pro-regulation interests in support of this proposal not only do not apply to commercial legal finance, but seem to be nothing more than a parade of hypothetical horribles. We believe that the legislation under consideration is unprecedented and would establish overbroad regulation that will adversely affect Kansas businesses and law firms by restricting their access to this type of capital, which is really a market-based solution to a business need of companies engaged in litigation. If this bill is passed, Kansas would become the first state in the nation to enact a law that includes both cost-shifting mechanism in matters involving financing, as well as a forced disclosure of all legal finance agreements. The vast majority of courts and legislatures have rejected similar proposals of forced disclosure of financing agreements in commercial matters, basically declining to add unnecessary rules or regulations and implicitly recognizing the potential adverse effect of such regulation on business and the legal industry. And the effects include drawing out and increasing the costs of litigation and potentially exposing privileged and proprietary business information. Anyone who has witnessed high-stakes commercial litigation knows that demands for disclosure of irrelevant information are a common mechanism of delay and to drive up the costs of litigation to one's opponent. And there's no doubt that forced disclosure of funding agreements would make the problem worse. Regardless, in a free market economy, parties are at liberty to contract and should be free to do so without being forced to disclose their confidential financial arrangements, particularly to an adversary in litigation. There is no basis for one litigant to have disclosure about the confidential financial arrangements of another. Courts do not inquire into the various business relationships that litigants have because they are rightly considered irrelevant. Commercial legal finance is another such private financial transaction. And no one is calling for banks, for example, to disclose their security interests over fee receivables in law firms. But those arrangements are just as much litigation finance as what specialist litigation finance firms do. And they happen in significantly greater volume. It's also important to note that ILFA's members are passive outside investors, meaning they have no control over the matters in which they invest and do not constrain or interfere with the counterparty's ability to resolve an underlying matter. The ultimate decisions are left to the client and the client, between the client and the client's lawyer. And just as a leasing company does not tell you how to drive your car, a commercial legal finance company does not control the matter for which they provide capital. And furthermore, I think it's important to note that these investments are primarily non-recourse, meaning that the provider's return is dependent on a successful outcome. And that, I think, is key to understanding why the types of cases that our members invest in are meritorious, because there is no return if the case is not successful. Furthermore,
Mr.
there's no debt.
Barnett,
Yes.
kind of consistent with other conferees, I've allowed a little bit more than 3 minutes. So if you could just wrap up, and as I have with you, if you could just wrap up your final thoughts, we can try to keep on schedule.
Oh, of course. And so I just want to conclude by saying we don't have a blanket objection to tort reform. We don't believe this is tort reform. And we just think in the end, this is overbroad regulation that is unnecessary in Kansas. And to conclude, we thank you for your consideration, and obviously would love to continue to engage as you continue to consider this legislation.
Thank you. Committee, next we will hear from Andrew Cohen, Director, Burford Capital. Please introduce yourself and welcome to committee.
Hello, my name is Andrew Cohen. I want to thank the committee. Thank you, Chair, for allowing me to testify today. And I want to be here today as a resource, someone who's actually engaged in litigation finance. I've been at Burford Capital for 10 years, and my job is underwriting the litigations that we invest in. When our CEO was on 60 Minutes and said, talked about our record, that is the point of what I do, is to make sure that we are investing in good meritorious cases, because if we invest in bad cases and the cases lose, we lose money. And then the concern that litigation finance is going to lead to a bunch of frivolous litigation, I think is a little misplaced, because again, I do not want to invest in litigation for litigation's sake. I want to invest in good cases. That is my job. As other folks have already stated, in every deal that I've done over the past 10 years, it's very clear that the funder does not control litigation. We don't control the day-to-day decisions, and we don't control settlement decisions, which is why, again, we need to craft our deals to make sure that all of the incentives are aligned between funder, litigant, and lawyer, so that the case can go through to its maximal value. I will try to be as brief as possible and just point out a couple of things about this version of this bill. It has a joint liability for cost provision, which is very unusual. The idea of apportioning joint liability between funder and litigant really should be a matter of contract between the funder and the litigant. Certainly we could contract for that obligation, and then we would be responsible for it. But absent that, the client is not paying for that obligation for us to undertake. And so it seems unwise to simply put that on the funder for no apparent reason. And I do want to point out sort of a larger point that all litigation is funded, whether it is funded by the party themselves through means of a contingency arrangement with a lawyer, by a bank, by some specialty litigation finance provider. The idea that this bill singles out a specific type of finance for penalties like limiting the ability to issue non-party subpoenas, which again seems a little bit just arbitrary. I don't fully understand why this form of financing is being called out as opposed to anything else. I don't think there's a reason to penalize parties for managing the finances the way they see fit. And finally, I'll just note that I appreciate that the GAO report was brought up. Burford participated in the information gathering process that led to that report. I think that it was a good report. I think it talked about the industry generally. I think it was very fair, and it clearly delineated the difference between commercial finance, which is what Burford does, and consumer finance, which is what other folks do, like the members of ARC. And I think it raised some good pros and cons of the industry, but it certainly didn't call for regulation, and it certainly didn't call for regulation of the type that is being considered in this bill. So I would just suggest that folks take the time to read that report and understand what the industry is about, and not jump to the need for regulation where that wasn't stated. Thank you.
Thank you. Appreciate that. Next, we will hear from Jack Kelly on behalf of the American Legal Finance Association. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, and I want to appreciate the time and effort for allowing us to be here today. My name is Jack Kelly, and I'm the Managing Director for the American Legal Finance Association. I don't mean to emphasize the American, but my mother once told me, my good Irish mother, that imitation is the sincerest form of flattery. You heard earlier from a group called the International Legal Finance. They're a relatively new organization that represents the commercial side of the business. Alpha, which has been around for almost 20 years, the American Legal Finance Association, is a group of 30 of the nation's leading and largest consumer legal funding companies. We have been established for many years in cooperation with the various regulators throughout the United States. And the cornerstone of our organization is transactional transparency, and particularly in transparency of disclosure of information for the consumers who use our products. Our members all ascribe to that. Our funding companies provide funds to the individuals for their personal needs, as was referenced by Eric Stafford earlier. It's critical for the committee to know that we do not provide any funds for any cost or fees or expenses that are related to the prosecution of the litigation. Therefore, when we provide a plaintiff funds, it's for their use for their personal needs, to pay rent, to get a car fixed, to make sure they have food on the table. We have nothing to do, in fact, with the actual litigation. We prohibit our individuals who receive fundings from us from that money being used for the cost of prosecuting the litigation or for the attorney fees involved in that litigation. We prohibit our companies, and our members are prohibited in many cases by law that we've advocated for and supported, where the statute actually prohibits the attorney of the company from being involved in the decision regarding the litigation. We are prohibited from paying referral fees and using false and misleading advertising. But most of all, we require solely that the attorney acknowledge that the funding is there for the purpose of the person's individual needs. We have nothing to do with the creation of litigation. By the time we get involved, when a person needs money, the case is already long established and already being provided. We're not in the business of making decisions about litigation. All we are in the business of is providing people a helping hand. In fact, 78% of the funds that we provided are used to avoid foreclosures, 7% are used for auto payments, and 10% is used for basic needs like food. We've led the charge throughout the United States in adopting sound regulations for this. And in fact, at the end of the 60 Minutes piece, the law professor that was cited earlier said this is a needed product, but may warrant regulation. And we've advocated for that. And in fact, we have supported and been part of regulation for our type of product, the consumer litigation funding, in Oklahoma, Utah, Nevada, Tennessee, Vermont, Ohio, Maine, and Nebraska. We look forward to working with the committee. We appreciate Eric Stafford and his willingness to exclude us from the provisions of this act. We think that we provide a service that we hope that Kansans can continue to have. I hope I haven't used too much time, Madam Chair, and I am happy and more than available to respond to any questions you or the members of the committee may have.
Thank you. Appreciate that. Are there any other opponent in-person conferees in the committee meeting room or on WebEx? Seeing none, then committee, we also have opponent written only testimony in your committee materials from Joseph Molina on behalf of the Kansas Bar Association. We're now going to turn to questions for our conferees, and I'm going to start with a few for Gary Barnett of the International Legal Finance Association. And my question is, we heard that from some of the conferees today that this is not a problem in Kansas. This is a coast problem, East and West Coast. So my first question is, you have retained a Kansas lobbying firm to lobby here in Kansas who testified today. So why do that if this isn't a problem in Kansas or a problem that's going to come to Kansas?
Well, we think it's important that the laws that are passed in any of the states in the U.S. as it relates to the industry, that they're done in a way that we think is appropriate. And so, whenever there's any sort of legislative activity that involves the commercial legal finance industry, we want to make sure that those who are considering the issue are well informed and have the kind of the relevant information that we think is important. And so I think it's one of the kind of responsibilities of the industry association to provide that service and to advocate on behalf of the industry. And I think it's important for potentially the future businesses and law firms in Kansas who might have an interest in the future. But I think it's important, again, to emphasize that it's not a problem in Kansas. No one has pointed to and it's not a problem anywhere where it's being used. And so I think that it's important to understand that when one is trying when folks are talking about trying to implement regulation on any industry.
Thank you. And we heard, at least I heard, some confusing testimony. Some of the opponent testimony was talking about the financing or not financing creates a small versus large, a small plaintiff versus a large defendant company. And in your testimony in particular, you talk about ILFA represents the commercial legal finance industry, which is entirely separate and distinct from consumer litigation funding. Commercial legal finance refers to the provision of capital to law firms and businesses represented by sophisticated counsel, typically in the form of multi-million-dollar non-recourse investments. So we also heard then from Alpha. So it sounds like we're talking about two different parts, the small versus large. ILFA doesn't really play in those kinds of litigation. It sounds like it's business to business, large, multi-million-dollar investments, quite frankly. Do I have that right, what ILFA's role is?
So we represent the commercial legal finance industry. And when we talk about kind of the smaller cases, the example that was given in 60 Minutes of Craig Underwood is kind of the example of what would the small be. And so it's smaller companies against larger corporations that are very well resourced. And so that's kind of the distinction in terms of the sizes and the level of the playing field. But it's a financing tool that is, I think, of interest to both companies, large and small, startups to Fortune 100 companies. But one of the benefits that I think is always important to point out, and I think Craig Underwood is a good example of it, is the level of playing field kind of benefit that the industry is able to provide.
And this would, the proposed bill, it sounds like, could level the playing field, because oftentimes a defendant in large cases has insurance, the benefit of insurance, and then so you're disclosing the insurance on the defense side, and this would be disclosure on the plaintiff side. So it looks like it's leveling the playing field, and we're not talking about the small consumer litigation where we have Alpha helping with plaintiffs pay. We heard their mortgages, their car payments, and things like that. So if I have it right.
Yeah, I mean, the only thing to mention that I think is an important distinction between the insurance agreements, which appears to have, which is a permissible for discovery, is that the insurance companies, they take over and control the litigation, and which is different than what our members do, which is their passive outside investors. And so I think that's an important distinction to keep in mind.
Have your hedge fund investors and your investor association members, have they funded the personal injury type of cases that we see advertised on TV?
No, I mean, our members are engaged in, and ILFA represent the commercial legal finance industry.
Are there any restrictions on how money you lend is to be used by the law firms that you lend them to?
I think every deal is different, so it's hard to answer that question in kind of the broad way. And so if there's, anyways, I think that if there's kind of more specific questions, we might be able to answer that. And I don't know if Mr. Cohen might be able to provide some additional color on that. But kind of every deal is somewhat every investment is somewhat different.
And your organization is relatively new, right? It was formed in September of 2020, if I have that right?
That's correct. ILFA was founded in September of 2020.
And what was occurring then? Why all of a sudden this investment by hedge funds in litigation?
I mean, obviously, this has been the industry has been, I think, talked about more and more over the last 10, 15 years. And I thought that they thought it was important to have a industry association represented. I mean, I think that this hearing today on this bill kind of shows why industry association is important for their interests to be kind of represented and put forward. And as kind of opponents of the industry, such as the Chamber of Commerce, kind of continue to be active. It was important for the industry to have an association of its own.
Thank you. Committee, other questions for the conferees today? Yes, Senator Gossage.
Thank you, Madam Chair. This question would be for Eric Stafford. If he could come forward. Thank you. The question that I have, it was brought to our attention on the 60 Minutes piece that this farmer won and then the company appealed. And then what should he do? What would he have done if he's exhausted all of his funds to be able to fight this? I'm just curious.
So if I remember right, it was a breach of contract case. And so it was explained in the series or in the episode that it was granting him access to funding to be able to pursue his litigation. And we're not trying to prevent that behavior. We're just wanting to know that it's out there. And not the dollar amounts, not the financial arrangements, not the percentages that he has to pay back or that she has to pay back, just to know that there's some sort of arrangement. And I think the reason why is to allow the defense of any company or of any size to determine, okay, do we settle or do we pursue through trial? So I don't think he should have done anything different. I think the fact that that funding was there is perfectly fine. It's not something that we're trying to prevent from happening or know the details of. So we're not trying to alter that individual's behavior in any way. We're just, it helps the defense paint the full picture, just like I think it was mentioned earlier about insurance requirements that are in statute today, just like those decisions help the plaintiff understand what they're looking at from a financial perspective on insurance coverage. So
it's would not disclose the amount, just disclose that he has an agreement.
That there's a third-party financial arrangement.
There is a third-party agreement. Thank you. Thank you, Madam Chair.
Yes, Senator Corson.
Thank you, Madam Chair. I had a lot of concerns when we heard this bill last year, and I guess my overriding concern is I continue to think that is simply just not necessary, that this is not a problem. So I would like to hear from the proponents. My first question is, we continue to not really have any examples that this is a problem, that this is an issue in Kansas. I will just say, as a practitioner, I have an active civil litigation practice. I represent plaintiffs and defendants. I go to luncheons, I go to bar conferences, I go to continuing legal education courses. I just never hear Kansas attorneys on any side talking about this issue. So I would love to have examples, again, of this being a problem in Kansas that the legislature needs to address. And my second reason that I think that this is really unnecessary is we have an existing discovery process that really works well. So if for some reason a party believes that the existence of this agreement is relevant to a case, they can make that discovery request. The other party, if they want to, can object. And then if they cannot reach an agreement, then a judge can ultimately rule on that request. And that happens in Kansas courts. Judges rule on discovery disputes in Kansas courts hundreds of times a day all across our state. So it's a core function. So I'm just confused again on why we need an entirely separate process for this one narrow type of agreement, which is frankly rarely, if not ever, used in Kansas. So I would just like to hear from the proponents on those two questions. Thank you.
Go ahead, Mr. Stafford. Thank you for stepping up.
Sure. Thank you, Madam Chair, and thank you, Senator Corson, for your question. Ultimately, we don't know how big of a problem it is, but we do know from law firms that we have spoken to, both small and large, that they are being called about these potential funding arrangements to see if they have interest in partnering on specific cases. So we do know what's happening. We hadn't had those phone calls prior to the hearing last session, but we do know that those phone calls are taking place today, and it is becoming a problem. So having disclosure allows to paint the full picture so everyone can know how big of a problem this potentially is. So I think we now know that it's happening in Kansas, and why we've brought it back, which is also why we've brought it back in terms of we've seen our business legal climate ranking slip from 10th to 35th. So we're now the 15th best state in the nation for trial lawyers. And with the actions of our Supreme Court eroding non-economic damages caps outside of medical malpractice and some other business expansion of liability, those are the reasons that we are bringing Senate Bill 74, Senate Bill 75 to talk about what we can do to help improve our legal climate. This one seems to be, I would hope, pretty non-controversial. We're not trying to right now reinstate caps on non-economic damages. That would have way more trial lawyers in the room than there are today, but we're pretty limited on what we can do to improve our legal climate. And this is one of the areas that we're asking the legislature to establish a good state policy. And it is fairly new. So not many states have taken action up on it yet, but the fact that it's being brought up at national chamber meetings, it's getting put on the radar. We were just one of the first to introduce it last year. Wisconsin has passed something on it. But the fact that there is no disclosure requirement prevents us from fully understanding how big of an issue it is in the state. But again, I think that question that was asked at the beginning was very good. If it's a problem on the coasts, then why are there opponents?
What about the second part of my question about we have a just civil discovery process? It works. It works in all kinds of discovery. It's commonly, every civil litigation case goes through the discovery process. Why do we need this carve out for this one narrow type? Why can't this just be handled in the existing discovery process with our existing discovery rules?
Well, probably because in the past there were never hedge funds that invested in litigation that could potentially alter the outcome of litigation. And now we need to modernize our statutes to reflect changes in the marketplace. So is it a fairness issue? Yeah, absolutely it is. So these weren't around in the 60s. There wasn't an association in 1989 or 1999 or 2009. There was an association formed in 2020 because it's a new industry. This practice started 20 years ago, 30 years ago in Australia, and it made its way to the European Union, which is looking at establishing regulations just like this. And now it's made its way to the United States within the last 5 to 10 years. But again, it's estimated that the industry is about $13 billion, but we don't really know.
Thank you. We had a question next from Senator Steffen.
Thank you. This is for proponents, opponents, anybody, but if this is going on the coast, do we have any evidence, any data that it's leading to excessive or additional frivolous cases?
Thank you. Do we have a conferee? Mr. Behrens? Thank you. And could you please state who you're with again? Thank you. And your microphone on, please. Thanks.
U.S. Mark Behrens, U.S. Chamber Institute for Legal Reform. Madam Chair, Senator, again, you're asking us, can we prove something that is being hidden by the other side? So it's difficult to say that. There have been examples from time to time where the curtain is peeled back. And despite some of the testimony today that this is only in the commercial litigation space, we have seen complaints, for example, one out of Texas, where a plaintiff's firm was actively seeking money. In that case, they received somewhere, I think, $100 million in like 90 days that they deployed to buy television ads to go recruit plaintiffs. Our clients will tell you that we have seen in the mass tort context the number of television advertising, misleading advertising that you all dealt with in the last session with lead generators going through the roof. And where is all of that new television advertising revenue coming from? Many of our clients believe it's coming from outside funders. And those ads are running in Kansas. You can see them any day on TV all day long.
Thank you, Mr. Behrens. I have a few questions for you. And I want to say I have heard in my law practice that attorneys on one side of the case get unsolicited offers to, hey, we want to help fund your litigation. Please contact us. We'd like to help invest in your case here in Kansas. So it has hit Kansas, I would say. It sounds like it has. I've seen that. And also want to ask you, there's been some questions about the difference between insurance agreements and this, and maybe not a difference. Each should be disclosed. And regarding the current state of the law, a party may obtain discovery about the existence and contents of insurance agreements. Could you describe for the committee what that means, and without this bill becoming law, what it means to have to file a motion, have it heard, the expense and the time that often takes? Could you speak to that a little bit if you have experience in that in your law practice?
Sure, Madam Chair, members of the committee. I think this probably occurs most often in automobile accident cases. And even though the rule says may produce, I think it's just routine in the cases that when there is a slip and fall case, an automobile accident case, a med-mal case, in the very first set of discovery, the plaintiff's lawyer is going to ask for that insurance information. And my experience is they're going to get it. And so the plaintiff side is routinely getting information about what are the defendant's resources and wherewithal to fund the case. And this is essentially asking for the same type of information on the other side. I guess you'd say what's good for the goose is good for the gander.
And we heard some of the opponents testify that they have a high win rate and they pursue the cases that they do. They invest in the cases that they do, and they, because of that high win rate, and they don't engage in speculative cases. Can you respond to that?
Madam Chair, thank you. That's a terrific question, because it may be misleading to say that, well, when we win 90% of the time, that proves that we don't involve in speculation. I would say quite the opposite. The fact that you win 90% of the time doesn't mean that your lawsuits weren't speculative, because businesses settle cases all the time for business reasons that have nothing to do with the merits of the litigation. So our firm, based in Kansas City, predominantly does mass tort defense, defending companies in those ads we see on TV. We have seen this money deployed, used in television ads that generate thousands of lawsuits in a very short period of time, 10,000 lawsuits, 100,000 lawsuits in the case of one client. When you are a company and you're facing 100,000 lawsuits, even when the science is on your side, these companies still settle because they can never afford the defense cost in litigating every one of this many cases. The brand is being dragged through the mud. The stock is facing pressure. So companies settle all the time for cases that have nothing to do with the merit. I'll give you one quick example that just off the top of my head may have been the most extreme example. In the Xarelto litigation, Xarelto was a blood thinner made by a couple of different pharmaceutical companies. The cases were aggregated in a federal MDL, 25,000 plaintiffs. They picked the first 6 cases in bellwether, representative cases. Said, let's try the 6 and find out where this litigation's going. The defendants won every single one of the 6 cases. That would tell you these cases have no merit. They settled for $775 million. So that's probably the most extreme example I can think of off the top of my head of cases that were proven to not have merit that resulted in almost $1 billion being paid to the other side.
Thank you. And I have one last question. Why is this a priority for the U.S. Chamber of Commerce?
Madam Chair, members of the committee, it's a priority because, as the Iowa law professor said, this is changing the landscape of litigation in the United States. We have outside money coming in and greater concerns that it could be foreign money from people that are from countries that may be looking to hurt the competitiveness of United States business. And where we see these cases coming in, we are seeing more speculative lawsuits. We're seeing more of the misleading television ads running. We're seeing that litigation is prolonged, that it's more difficult to settle cases and more costly to settle cases. And those are all reasons that business has a big interest in this type of legislation.
Thank you. Committee, other questions? Senator Baumgardner.
Thank you, Madam Chair. Quick question, and then I have one for an opponent, but why isn't this bill just limited to disclosure if it's, or prohibition of out-of-country funding? Why isn't it just limited to that? If what we're concerned about is someone from China or groups from other countries are trying to damage commerce here in the United States, why isn't it just limited to that?
Madam Chair, Senator, good question. When the GAO looked at the current state of the industry and the number of companies that are represented by the associations we heard today, I think the GAO's count was that there's 47 different funders, and 2 of those admitted that they had received investments from foreign sovereign wealth funds. So this is an issue, and that is a policy decision for the committee. I'm not the policymaker, I'm just providing expert testimony. But one thing the committee may consider is banning this type of practice when there is foreign sovereign wealth money that is involved. But beyond that, that is just part of the funding that's coming into the industry, and it doesn't go to
Madam Chair,
the other problems we talked about.
In debate, we would refer to that as power tagging. I mean, we've heard a lot about out-of-country funds coming in, and if it's only 2 out of what you said, 73?
Out of 40 or so funders, there were 2 that admitted to GAO.
Yeah.
But the publicly traded companies, who knows who's buying their stock?
I understand. Thank you. This is for Mr. Federico.
Thank you for coming forward, Mr. Federico, and please introduce yourself and who you're with after the question. Thank you.
John Federico on behalf of ILFA.
Or before the question.
There we go. My question is, a lot of law firms are located in multiple states. So in your opinion, is it possible that if an office in a different state were to receive funding, which would impact that overall corporate law firm, that would have to be reported as well?
That's a good question. I'm not sure.
Well, the liability of a law firm is when when they have multiple locations, it's entirely possible, isn't it?
It is. Our approach from the beginning, thank you, Senator, our approach from the beginning has been, it almost appears that this funding mechanism is being vilified because they make a profit. And I want to make sure that there's the distinction between loaning money and putting risk-based capital to work. 90%, they review the cases, and the 10% that they fail, they lose. These are not loans. There's a big distinction between the two lending mechanisms. This is a lifeline many times for people. I just heard the last conferee say that it prolongs litigation and forces it into settlement. Well, again, this is oftentimes big versus small. I don't see that as a bad thing to stay the course. I'll reference back to the farmer, a $23 million settlement who had no money to appeal that. He would have settled for pennies on the dollars. Clearly, the jury or the judge found that his case had merit. And so what would have been the situation for that small farmer had he not had this as an available source? What is the sin that they make a profit? They research it, they invest in those cases where they think there would be a return on investment, and I don't understand where all of a sudden that becomes a problem. The question you asked, Senator Gossage, to Mr. Stafford, this goes beyond just disclosure. If you look at page 2, you have to hand over the contract that you have. As a private citizen who sought financing from this particular company, you have to turn that over. For what purpose? Again, they're not a participant in the lawsuit. They're a funding source. Different from an insurance company that oftentimes takes over the litigation and might have to disclose that information. You have, if you put this into law, you have removed that option for the judge to decide whether this information is relevant or not. The Kansas legislature has decided, regardless of the circumstances between these two contracting parties, you need to hand that contract over to the adversarial side. It's a head scratcher for me. I don't understand it. This has been introduced in many states: Florida, Texas, Missouri, Ohio, Georgia, North Carolina, Utah, Louisiana, all rejected.
One last question. If an individual were to provide funding, would that have to be disclosed?
It appears so. Any non-lawyer, non-participant in the lawsuit would have to disclose, whether it be grandma or...
It could be parent, it could be sibling, it could be anyone.
That's how I read this.
Thank you. Thank you, Madam Chair.
Thank you, Mr. Federico. I'll have to challenge your reading of this regarding the disclosure by a parent or grandparent or other third party. It's only if that contracting party has a right to receive compensation out of the litigation.
Right. It could be the scenario that was presented didn't say how that was laid out, but that could be a situation where they'd have to disclose that.
Only if they're to receive compensation. If they're just helping pay and I don't want anything for it, I'm just helping you out, then they wouldn't, according to how it's written, have to disclose that.
Correct.
So, okay, it's only if they receive, if they're going to receive compensation if the litigation is successful.
So, Madam Chair.
Thank you.
Madam Chair, compensation, would that be if the funds were to be returned to the individual that was giving you the money for it?
That'd be a question for the reviser. A right to receive compensation that is contingent on and sourced from any proceeds. So the reviser can interpret it for us that if there's money paid, well, it's only if there's money paid to the party that's sourced from the proceeds of the civil litigation.
Thank you, Madam Chair. There could be a distinction between compensation and reimbursement, but I don't know that I want to step in and say either one's correct at this point, as I think we have a couple different opinions on whether that's compensation or not.
And I think Mr. Behrens, as a proponent of the bill, has some thoughts on that as well.
Mark Behrens again for the U.S. Chamber. I just wanted to clarify in the language. So in the case of grandma that makes a loan or anybody, the disclosure only applies if this is a non-recourse loan. In other words, before the funding industry came along, a decade or so, lawsuits were brought in Kansas. Lawsuits were brought all over the United States. How did lawyers fund lawsuits before this new industry sprung up? Either the lawyers funded it out of their own pocket, or they associated with other firms, bigger firms, deeper pocket firms, and that still goes on today, or you get traditional bank loans. So I know like our firm has a revolving line of credit, we get bank loans, and you pay back the bank with interest. That's not covered here. This is non-recourse loans. This is when somebody says, I'm going to give you money and you don't have to pay it back unless you win. So it's not a traditional bank loan. Those wouldn't be covered here. It's only when the person making the loan is essentially doing it on a contingency fee basis, just like the lawyer bringing the case.
Thank you. And one other question, Mr. Behrens, that was brought up earlier. You work at a law firm that has offices in different states other than Kansas. And there was a question about if one branch of your firm were litigating a case, and would this apply? Could you explain how that would apply to firms that have more than one office, some of them outside of Kansas?
Sure, Madam Chair, members of the committee. The way I read this is it's based on where the lawsuit is filed. And so if the lawsuit is filed in Kansas and our law firm, wherever we have offices, receive third-party funding, we would have to disclose that. And that's our any plaintiffs, anybody that's in a firm taking a plaintiff's firm, in this case, we generally don't do plaintiff's work, but anybody that's doing plaintiff side work, that's bringing a case in Kansas state court, this is where the bill would apply. If their firm had received funding, they would have to disclose that. It's triggered by the location of the lawsuit in Kansas, I think, not the location of the firm.
We're going to wrap up in just a few minutes because we are sort of a noon committee, sort of not. It's and want to be conscious of and aware of people's plans to get out and go to lunch. So did we have a question from Senator Baumgardner?
I guess a clarification. It seems to me with that language that a firm could be getting funds for an entirely different case, but if one's filed within that, if any other case is filed within the state, they would have to still disclose that. Thank you, Madam Chair.
I'm not sure I understood the point of clarification there, but if the committee did, then.
Firms handle multiple cases. And when they get funding from the outside, that's money going to the firm. It's money going to the firm, just like a loan, a revolving loan. It's not specifically for a case, but it's coming into the firm to keep it moving.
So that's something that hasn't been addressed, and I will ask a question, I guess, to ILFA. Do you speculate on particular cases and you do that case by case, or you just simply fund and invest wholly in a law firm and then they decide which cases they're going to file where? Because my understanding was it was a case by case investment and speculation rather than you're just funding a plaintiff's law firm.
Our members primarily invest in individual cases or a portfolio of cases. But it might be helpful for Mr. Cohen to also answer that particular question.
Thanks, Mr. Barnett,
Sure,
and thank you,
Mr. Cohen.
thank you, Madam Chair, for the question. This is Andrew Cohen from Burford Capital. We invest in individual cases with a single claimant. We invest in portfolios of cases with claimant, so claimant-side financing of portfolios of cases. We also invest in portfolios and single cases of with law firms. And those cases could be in a single jurisdiction, they could be across jurisdictions, they could be single type, they could be cross type. So I think the answer to the previous question is it's complicated. And I do not read this statute or this bill as requiring disclosure by law firms ever. This is talking about a person that has a right to receive compensation. This is about parties. This isn't about lawyers. So I think maybe I'm just misreading it, but the statute does not clearly say to me that the lawyers who are taking funding are subject to disclosure or sanctions or anything else here. I do have some other responsive points to some of the other points that were made earlier, if I may.
Actually, I'm sorry we're running out of time to circle back, but to finish up on this question that we're on currently, if Mr. Stafford can provide some clarification about if there's it seems to me it would apply to a single case, but if Mr. Stafford could provide some clarification about the disclosure would apply. If a hedge fund is investing in a law firm, then the disclosure would only be made when that law firm then files a lawsuit in Kansas, or would that be an instance of when disclosure would be triggered by the bill?
I would defer to Mark.
Okay, sorry.
I'm sorry, Madam Chair. Mark Behrens with the U.S. Chamber. Could you repeat the question? I'm sorry.
Sure, just kind of trying to clarify this last question, that if one of these hedge funds invests in a law firm and the law firm, files cases in different jurisdictions and a lawsuit is filed in the state of Kansas, the disclosure requirement would apply to that particular case, not to all the cases that the law firm might file in other states. Is that correct?
Chairman, that's how I read the language.
Okay, and I hope that clarifies that last point we were trying to work on. But committee, with that, we will thank the conferees for their testimony, both in person and on WebEx, and thank the committee for their attention and the questions raised. And we will then close the hearing on Senate Bill 74. And before we adjourn, want to make sure we don't have any other requests for bill introductions, which I know we have at least a couple over here from Senator Baumgardner.
Thank you, Madam Chair. And I was late because I was testifying upstairs, so I appreciate that indulgence. The first one is RS 0918. That is to reintroduce the Senate's version of the Office of Child Advocate.
Thank you. The bill is so introduced. Committee, we were going to take a look at meeting minutes. We have run far over time.
I have one more.
Oh, Senator Baumgardner. I'm sorry, I have another.
That's right. Thank you. It's RS 0911. It is an appeals bill.
Thank you. The bill is so introduced. We will take a look at approval or changes to the meeting minutes next week. We are not meeting tomorrow. Meeting is on call of the chair on Monday in case we have any requests for bill introductions. I don't anticipate meeting on Monday, so I do anticipate our next meeting is Tuesday, and want to thank everyone for their attention, both in the committee meeting room and those following along online, as well as staff today as well. Thank you very much. And we need to, we will reschedule the hearing for Senate Bill 75. And we are adjourned. Thank you.